To this November 3rd, 2011 webinar, and realtors later watching this via the archives. Today we have a very special guest, Jim Knight. He's the Administrator, Office of Immigrant Worker Compliance, South Carolina Department of Labor Licensing Regulation, LLR. He holds a Bachelor of Arts and Master's degree from the University of South Carolina. He's been LLR's liaison to businesses for 30 years on labor laws covering OSHA, payment of wages, child labor, and mediation. He's a U.S. Air Force veteran, and he's married with 2 sons. Mr. Knight, thank you for joining us today.
Thank you, and good afternoon, everyone. The South Carolina Illegal Immigration Reform Act is the topic of today's program. We're going to talk about the original law that was passed in 2008, but more importantly, we're going to talk about key amendments that were made to that law in June of this year. The South Carolina Illegal Immigration Reform Act that was passed in 2008 covered a multitude of things, including making it a felony for anyone to hide, protection, an illegal person, covered public employment. But what we're focusing on today, and our responsibility for enforcement in the South Carolina Department of Labor Licensing Regulation, is that section called Illegal Aliens and Private Employment. The 2008 law required every employer in the state that employs one or more workers to verify their new hires at the time of hiring. And the 2008 law gave employers 2 options as far as doing the verification. One, they could verify the new hire using a federal database called EVerify, which was set up about 5 or 6 years ago by the U.S. Security in cooperation with the Social Security Administration. And we'll talk more about EVerify in just a few minutes. The second option in the 2008 law for verifying a new hire was to get a South Carolina driver's license or ID from that new employee, or have the new employee provide you with a driver's license ID from a list of states that our DMV had determined had requirements as strict as South Carolina in getting a driver's license ID. And when the final list was tabulated by the DMV back in 2009, when we began enforcement of the law, there were only about 25 states that made the cut. Initially, states like North Carolina and Tennessee did not make the list, although they were added a few months later. But in the end, still, California, Washington State, New Mexico, Louisiana, New York State, etc., they never made the list. And came into South Carolina from those states 2009 up until May of this year, when we were enforcing the 2008 law. You could not employ a person with a driver's license from that state unless they obtained a South Carolina driver's license, or they demonstrated that they qualified for a South Carolina. During the 2 years that we enforced that law passed in 2008, we conducted audits of almost 6,000 businesses in South Carolina. We identified 500 employers who were not complying with the requirements of the 2008 law. They were citations, assessed monetary penalties. As I said, we were enforcing that law for almost 2 years, and in May of this year, there was a decision that came down regarding the Arizona immigration law. South Carolina's law was passed in 2008. Arizona had passed an immigration law in 2007, and the South Carolina law was patterned in part on the Arizona law. And the Arizona law required that employers use the federal database EVerify to verify new hires. The U.S. Chamber of Commerce had sued the state of Arizona over their immigration law, And they'd asked the U.S. Supreme Court to basically decide two questions. One, can a state like Arizona and then South Carolina, others who were jumping on this immigration law bandwagon, adopt their own immigration laws? And then second, can a state like Arizona and now South Carolina mandate that employers use this federal database to verify their new hires when this federal database is voluntary on the part of the federal government, and it's voluntary in every state that has not mandated that employers use it? Well, the court, in its decision in May of this year, said yes to both questions, that yes, a state can adopt its own immigration law as long as it doesn't stray into an area where the federal government has maintained. Second, a state can mandate that employers verify their new hires using this federal database, EVerify. Well, on first reading of that Supreme Court decision in May, we thought we were in good shape with the South Carolina law because, as I said, it was patterned on the court. But as our attorneys dissected and analyzed the court's decision, they came to the conclusion that the 2008 law that we had been enforcing for 2 years was likely unconstitutional. And if we continued to enforce it, it's just a matter of time before we'd be challenged in the courts as to the constitution. Two problems with the 2008 law, in the opinion of our attorneys, was one, the monetary penalties. It was clear that the court had said that only ICE, Immigration Customs Enforcement, could assess monetary. And ICE typically does that when they do an I-9 audit of businesses. The I-9 form has been required since 1986 of employers to complete that as they hire new employees. I-9 forms are subject to audit, and ICE could come into a place of business, completing the I-9s and keeping them as required by law, and assess monetary penalties. And they also assess monetary penalties where they find that. But the court said that a state such as South Carolina couldn't assess monetary penalties. And then the other problem with that 2008 law was the driver's license option for verifying. Something in the 14th Amendment to the Constitution that talks about a state will not adopt a law that abridges the rights of citizens in other states. And what we had done in South Carolina, in essence, in 2008 was we had erected borders at the North Carolina, South Carolina, Georgia, South Carolina line, and we were telling these folks on that list of non-approved states that our DMV had put together that if you come here from California, New Mexico, Louisiana, for example, you need not come here and try to practice your trade or profession unless you get a South Carolina driver's license or you demonstrate that you qualify for a. So with the court's decision, we shut down our audit program effective May 21st of this year. And we notified the legislature that we would no longer be able to do audits, enforce the law as written in 2008. We laid off something like 23 auditors and supervisors working in the program for almost the legislature was still in session in Columbia, debating the budget for the next fiscal year, and we fully expected that it was January before they take up this issue. But in less than 3 weeks, they had amended the 2008 law where they constitutionally, and we will be back up and running again, enforcing a state immigration law January 1, 2012. As an employer in South Carolina, here's what you need to know as far as your responsibility for compliance with this amended state immigration law. Beginning on January 1, 2012, every employer has to register with EVerify to participate in the program. At the stroke of midnight on December 31st, 2011, by that time, every employer in the state is supposed to enroll in EVerify, because if you're not enrolled at a second past midnight, January 1, 2000, law. And then from January 1, 2012 forward, every time you hire a new employee, you have to verify that new employee within 3 business days through EVerify. Now, you don't go back and verify those employees already on the payroll. EVerify rules prohibit that, and the South Carolina law expects you to security. So you only verify those new hires coming on board after January 1, 2012. I said that the monetary penalties went to the wayside. We can't impose those anymore. So what gives the South Carolina law teeth? Well, in the original law that was passed in 2008, every employer in the state was imputed a license to operate their business. Imputed means that it's not something tangible that you can hold in your hands, unlike the 300,000 or more licenses that we issue to professionals and occupational all across South Carolina within LLR. You don't pay a fee, you don't apply for it, you don't take a test for it. You got it automatically when Mark Sanford signed the 2008 law. As a real estate professional, it's an addition to the real estate license that's been granted to you. Granted automatically to every employer in the state, granting them the right to operate their business, and you get to keep that license as long as you comply with the South law. But if you run afoul of the state immigration law, you lose the right to operate your business. Well, the legislature was not satisfied when they were amending the law in 2011. They decided to go a step further, and they said that license is also going to mean any agency permit, certificate, approval, registration, charter issued by any government entity in this state, whether it's local government, state government. So if you're a bar in Horry County, not only are we going to sanction your state imputed license under this immigration law, we're also going to notify the Department of Revenue, which issued you the liquor in the establishment, and they too are going to sanction the liquor license. And that's the case too with a permit to operate a business that might have been issued by government or city government. Professional licenses are excluded. I think the reason they excluded professional licenses was because of the red tape involved in suspending a professional license and then state it again. But folks with professional licenses would not find themselves free from compliance with the statute, because as a professional, if you operate a business and you employ a person, then you'd have to shut down your business. If you're a broker and you employ people and you're found to be employing unauthorized workers or not complying with the South Carolina law as far as having enrolled in EVerify and haven't verified your new hires through EVerify since January 1, then we would shut your business down. And during that period of time, you couldn't employ people, you couldn't operate. Now, what about those folks on the payroll hired prior to January 1, 2012? Federal law and under state law, nobody is grandfathered in. Federal law and the state law says that a private employer shall not knowingly or intentionally employ an unauthorized worker regardless of their date of hire. Under the South Carolina law, if you ever have knowledge that an employee is no longer legally and authorized to work in this, you have to call that worker in, examine their document, determine that they're no longer authorized to be here working. You have to terminate the worker. But having said that, under the South Carolina law, you have no burden, you have no responsibility to go looking at your current workforce in place prior to January 1, 2012. You don't have to call in individuals and look at working. In fact, attorneys that I talk to say that started that process and you didn't handle it in the correct manner, then you could get yourself in a situation where complaint and the U.S. Justice being in your place of business, rights violations. And they say that they tell their clients that if they're going to have heartburn about whether their workforce in place prior to January 1 is legal or not, and they want to check again the documents of the employees working for them and update their I-9 forms, then you've got to do it for every employee on the payroll. Because the concern is that an employer would discriminately pick and choose, maybe based on accents, on color of skin, going after a certain class of that's where you'd get into trouble with the justice. So if you're going to go back and look at your workforce in place prior to January 1, 2012, look at the documents of everybody. But again, under the South Carolina law that was passed, you have no responsibility to go back and look at employees on the payroll January 1, 2012. Only have a responsibility for enrolling EVerify and then verifying those new hires. How will we enforce this new law? Well, beginning on January 1, 2012, up until July 1, 2012, the first 6 months, we will be issuing warnings to employers. There'll be no sanctions if we find that an employer is not enrolled in EVerify or has not been verifying the new hires through EVerify. We'll give that employer an opportunity to come into compliance with the law, and then if they will affirm in writing to us that they're complying with the South Carolina law, they've enrolled in EVerify and they're verifying the new hires within 3 business days, and they're complying with the federal law that requires them to complete I-9s on new employees hired since January 1. There'll be no sanctions way. But after January 1, 2012, after January 1, 2012, if we go into a place of business and they have not enrolled in EVerify, or They have not been verifying the new hires hired since January 1, 2012, 3 business days through EVerify. The law says that we have to immediately put that business on probation for 1 year. And during that 1-year period, the employer is on the hook in that they have to submit quarterly reports to LLR demonstrating they're complying with the law. Quarterly reports would consist of information showing who they've hired during that quarter, how they verified those new hires, and what the status is of any employee who. And then, if that employer has a second violation for failure to enroll in EVerify or failure to verify a new hire through EVerify within 3, have a second violation within 3 years of that first violation, and the employer had a violation. On the second violation, we have to suspend the license of the employer for 10 to 30 days. Also, if we determine that the employer is employing an unauthorized worker, we have a duty to notify ICE, Immigration and Customs Enforcement. Don't want to get to that situation to where we're handing off information about your business to the federal guys, because those guys, unlike the LLR auditors, they carry guns and they have authority to arrest business owners. And ICE has done that in the past in South Carolina. Went in and initially they focused on the management of the company and the HR director and supervisors, and they arrested them, and then they came back a couple of weeks later with their workers working in the facility. So because you're in management, don't think that ICE will ignore so we have a duty to notify ICE if we identify illegal workers working at an establishment. We did that probably 100 times under the old law that we were enforcing. So we have to suspend the license for 10 to 20 days on a second-time violation. And if you have violated 41.830, which is knowingly and intentionally employing an illegal worker, forget about the warning period I talked about the first 6 months. Forget about a first bite at the apple and that you go on probation for a year. If you are found to be knowingly and intentionally employing an unauthorized worker, there's no warning, there's no probationary period. First time violation, we only get that first time warning or probation if you are found not to enroll in EVerify or knowingly intentionally employing an unauthorized worker. Days, and during the period of suspension, the employer can't engage in business, can't employ a person, can't sell or manufacture. Or in the case of a broker, you couldn't. And to get that license back, if you lost it, you'd have to demonstrate that terminated any illegal workers and pay a fee of up to $1,000 to cover the violation. And on subsequent violations for knowingly and intentionally employing an unauthorized worker, the suspension time keeps increasing. Second time, 30 to 60 days. Third time, license is revoked, and after 90 days, you can petition the LLR director to get that license. And for a fourth occurrence of knowingly or intentionally employing an unauthorized worker, the license is revoked for years. And if your license was suspended or revoked and you decided to operate your business during that period of suspension, we would have to move immediately to revoke your license. Tell employers as I travel across the state and speak to that the South Carolina Illegal Immigration Reform Act, as it pertains to employees, the toughest immigration law in the country. I saw a headline the other day that said that Alabama, which has an immigration law, the toughest immigration law in the world. That because in some countries, I think they shoot you if you. But I do know that when it comes to an immigration law that affects employers, no state, including Alabama, has a law tougher than South Carolina. For example, in Carolina law, it applies to every employer that employs one or more workers. In North Carolina and in Georgia, for example, where they have adopted immigration mandating that employers enroll in EVerify, they set in North Carolina, for example, a threshold of 25 employees or more before you have to. In Georgia, it was 10 employees or more. But in South Carolina, if you've got one employee, you've got to enroll in EVerify and comply with hires. South Carolina is the only state that has auditors in the field auditing employers to check to see that they're complying with the state immigration law. The North Carolina law, the Georgia law, they don't have an enforcement mechanism in place. In the Alabama law and in the Arizona law, it's left up strictly to a complaint being filed with the county attorney before an investigation. And South Carolina has auditors in the field who are actively looking at employers, and as I said, and then third, the reason the South Carolina law is the toughest in the country. You can have your license revoked for employing an unauthorized worker, and you can have your license suspended for 10 to 30 days for what I call a record-keeping violation. Not having enrolled in EVerify, and for not, every time you hire a new employee, going into this database, taking the credentials, and in the Department of LLR, we have a program called OSHA. And if you're familiar with OSHA, the acronym stands for Health. And OSHA is about life and death in that we have safety and health standards that employers have to comply with. And if employers don't comply with those safety and health standards, then employees are at risk of being injured or killed on the job. And we see that every month, that a worker has been injured, he's lost a limb, or a worker has been killed on the job because employers regulations. But in the 30 years that I've been with the agency, and in the 40 years that we've had a state OSHA program, we've never closed down a business for a safety and health violation. We don't have that authority. We might tell the business to put a guard on this piece of machinery until you can use it again, And until you put that guard on service, or we tell you to engineer this toxic substance out of this area where employees are working, or put respirators on the workers. But we've never told a business that we're shutting you down. But under this South Carolina Illegal Immigration Reform Act, on a second-time record-keeping violation for not enrolling in EVerify and not verifying new hires within 3 business days, you can be And if the threat of having your business shut down or your license revoked was not enough, the legislature in 2008 put into the law what I call the Scarlet Letter provision. That is, we have to publish the names of every employer cited under this immigration violation on the LR website. Under the old law, we published the names of some 500 employers that we had found not complying. Names were there, their addresses, the violation that we had identified. And to their credit, we did state if they had but their names were published there indefinitely, because under the old law there was no time limit as to when. And I'm told by some employers that that was a huge incentive for them to comply, because particularly in small communities, for example in landscaping, competitors would whisper to potential clients that, hey, you don't want to do business with XYZ company because they're un-American, they're unpatriotic, they hire illegal workers, they don't comply with the South Carolina immigration law. If you don't believe me, go to the LR website and you'll see their name published where they have violated. Yeah, that's probably not fair, because those employers had come into compliance with the statute, but the way the law was written, their names were posted there indefinitely. And when the legislature amended the law in 2011, we were told that if an employer had committed a record-keeping violation where they had not enrolled in EVerify or had not verified new hires within 3 business days, first-time violation, your name would only go up for 6 months under this law. But on a second-time violation, or for knowingly and intentionally employing an unauthorized worker, again, your name goes up there indefinitely. Okay, how will we schedule our inspections under this new law? Pretty much like we did under the old law. We will schedule random audits. We will send a letter to a business. In the past, we would mail it out on Wednesday, and depending on how fast the mail moved, the employer would get it either on Thursday or Friday, and it would say that you've been selected for audit under the South Carolina Illegal Immigration Reform Act, and we will be coming into your and we'll be looking at records to make sure you're complying with the South Carolina law. So what records should you be prepared to have in place if you're selected for audit? Well, we'll want to see a roster of employees employed at the establishment. We'll want to see their hire dates. And then we want to see some evidence that the employer is enrolled in EVerify. Then we'll want to see documentation as to how those new hires were verified and what the result of the verification. The other way we can get into a place of business is through a complaint. The statute says that if we get a complaint that is signed and in writing that alleges that an employer is not complying with the South Carolina Illegal Aliens and Private Employment Act, then we have to. And then we can go in for good cause if directed to do so by the director of LR. An example of good cause there would be federal guys I talked about earlier, ICE. They could be in a place of business doing an I-9 audit, and they're familiar with the South Carolina immigration law, and they could pick up the phone and call us and say, hey, we're auditing this business and looking at their I-9s and looking at their private, determine that they're not enrolled in EVerify. If you want to read the 2008 law and amendments that were added by the legislature in June of this year, you can go to our LR website, and there's a link here on the page, and access the 2008 laws. You can also access the link to Verify to enroll in EVerify, information on future training programs that we're offering, and if you're a person who has great curiosity as to who's being cited in South Carolina under this immigration law, after January 1 of next year, you can go on the website and you'll see a listing as required by law of those businesses that have been. Now, let's talk about EVerify for a few minutes. What is EVerify? It's a no-cost, internet-based system. As I said earlier, it was set up about 5 or 6 years ago by the U.S. Security in cooperation with the Social Security Administration. It's fast and easy to use, and I always get a chuckle from the audience when I say that something offered by the federal government is fast and easy. But I swear I've used the system, and it is fast and easy once you get in. Because in seconds, it will tell you whether someone is authorized to be employed. And the key to making EVerify work is the I-9 document that every employer has been required to complete on a new hire since 1980. And if it's a U.S. citizen, on that I-9 form, you're going to take the person's name, their date of birth, security number, date of hire, the document that they produced to establish that they are, say they are, and you're going to hit the send button, and in 3 to 4 seconds, you're going to get a message telling you whether the employee is authorized to be hired. And if it's a non-U.S. citizen who has presented a permanent resident card, an employment authorization card, or a work visa, you're going to enter that person's name, security number, alien number, card number, and in seconds it's going to tell you whether that person. And here's the email address to enroll in EVerify, dhs.gov/e-verify, and again there's a link here. Page. When you get on the page and you click on enrolling in EVerify, you'll be asked to sign a memorandum of understanding with DHS and SSA, and that's where you agree to play by the rules. You will verify every new employee coming on board. Tell folks that the South Carolina immigration law does not discriminate, and EVerify does not discriminate. You have to verify every new hire. If you and I grew up in my hometown of Lancaster, and I had known you since childhood, in fact, my mother was at the hospital the day you were born in Lancaster. If you came in to my office on January 5th next year and made application to work, and I decided to hire you, and you came to work for me, I'd have to take your credentials off and the information off run it through the EVerify system to verify you. That's to keep an employer, again, from straying into a discriminatory practice to where they would be picking and choosing based on accents, So anyway, you agree to comply with EVerify rules, and then you get a password and an EVerify web address and username. You download and read the EVerify user manual, which if you're participating in this seminar today, and silly to ask because otherwise hear the question I've just posed. But by participating in this the seminar webinar, you're already ahead of the game because we've already talked a lot about EVerify. I'm going to talk some more in a second, to where it should be a quick read for you in going through this EVerify manual. And then you'll be asked to take an online tutorial. You have to make a 70, which is pretty easy. And the reason they do that they make you read the manual and do the tutorial, is to make sure you understand how to use the. And again, you verify only new hires coming on board after January 1st or after you enroll. And you don't verify existing employees, and you do the verification of the new hires within. When you enroll in EVerify, you're going to be asked to select the access method as to how you use EVerify. And 97% of people enrolling in EVerify are going to fall in that first column. I'm an employer using EVerify to verify my new hires. You can have a designated agent to do your e-verifications. Some employers will have their accountant, a payroll service, their attorney, a consultant to take on this responsibility. And so you would select. Or if you're a large corporation with multiple sites across the country, okay, we enter our information into the database, and the result is going to be, for most, in 96% of the cases, that first column there, employment authorized. The credentials and the information that were placed into the EVerify system matched up, and the person is employed, authorized to be employed. But in the other 4% of cases, you're going to get a Social Security Administration tentative non-confirmation, or a DHS verification in process, or a DHS tentative non-confirmation. Problem typically with a Social Security tentative non-confirmation is a married woman has applied for employment using her new married name. It's on her driver's license and the other documents that she's bringing in, and she hasn't contacted Social Security for them to update their records. So she's not going to clear the EVerify process. For a DHS verification in process or yeah, bureaucrats make errors, and information could have been entered into the system, or more likely, you've got a person there with business. Regardless, before I go into that, let me show you the screen that you would get on an employment see there, maybe in green there at the top of the page. It says employment authorized. Closely to the screen as the kind of information. And then we hit the send button, and then this is the screen that comes back in like 3 to 4 seconds. And at this point, we could click on the close button at the bottom because the database is going to record that you did this verification and the date you did it and the outcome. And if we come on an audit, you can go into the database and print out for us a listing of all your new hires since January 1 and what the outcome. But some attorneys and some employers, they're nervous about databases, and they go ahead and copy this screen. They print it out, and then they attach a copy to the I-9 form in case they get a federal audit, and then they start a file for state compliance and have copies of this. Strictly up to you as to how you want to proceed. Well, if you get an SSA tentative non-confirmation, or if you get a DHS tentative non-confirmation, you would click on Continue, and on the next screen, you would be instructed to download a form and then make 2 copies of that form. And that form is going to give instructions to the employee as to how to contest that tentative non-confirmation. You do not terminate the employee based on a tentative non-confirmation. That employee has a chance to challenge that tentative non-confirmation. Instead, you're going to download that form, make 2 copies. You're going to call the employee in your office, and you're going to say, hey, South Carolina law requires us to take the information you gave us that was part of the I-9 process. We have to run it through the EVerify database to affirm that the information is accurate. We ran it through the EVerify database, and it could not confirm your documents. Now, you have some options here. You can elect not to contest the tentative non-confirmation, and we'll part our ways. We will terminate your employment. Or you can elect to contest because we do know that bureaucrats make errors, and right to contest it and try to clear it up. But if you are going to contest it, you have the burden of responsibility to, within 8 federal government workdays, to make contact with either Social Security or Homeland Security. You make contact with them, they're going to notify us, and we will continue to employ you. We cannot take any discriminatory action against you based on this tentative non-confirmation. We can't lay you off. We can't demote your pay. We can't transfer you to another job just because you got a tentative non-confirmation. But if you fail to make contact with Homeland Security or Social Security Administration within 8 federal government workdays so that they can work to clear this matter up, they're going to send us a message back in the EVerify database telling us that you didn't make contact and to terminate you. But if you do make contact, you can continue to work here until the matter is resolved. And then at some point, we're going to get a message back from Social Security or Homeland Security saying that, hey, we've cleared up the matter and the person's okay to be employed. Or we couldn't resolve the discrepancy in the information, terminate the work. And EVerify used to have a weakness in it that if it was a non-U.S. citizen, there were a lot of phony documents that were clearing the EVerify system. And that, for example, Ho Chi Minh had gotten a permanent resident card 3 or 4 years ago, and it was valid in every respect because it was issued to Ho Chi Minh, and it matched up with his date of birth, the alien number, the card number, they were all good. But he either lost the document or he had sold it on the black market. Then all of a sudden there were 1,000 Ho Chi Minhs walking around, and they were simply lifting their photograph off the document, and the photographs were not in the database, and employers were simply entering the information, and it was coming back employment authorized every time. But now they've added the photo tool to EVerify, so if it's a non-U.S. citizen, the permanent resident card in your hand that the employee gave you at the time of hiring, that photo has to match the photo that's in the database, because if it doesn't, you can't employ. Okay, we're down to about 8 or 9 minutes. Questions? Do we have some questions? We do have some questions. Let's go ahead and get into some of those questions. I have read personally the suit that was brought by the U.S. Attorney for South Carolina. I've not seen the ACLU also has sued the state of South Carolina. I've not read that suit. But I can tell you that EVerify is not mentioned in the U.S. Attorney's suit. And the reason they didn't include it is the Supreme Court in the Arizona decision back in May has already said that a state can mandate that employers enroll in EVerify and verify their new hire. We feel confident that EVerify and it's carry forward. Now, other elements of the immigration law that was passed in 2008 and were added in the amendments in 2011, those are being challenged as they're being challenged in other states. Police stops, that's one that we feel confident that EVerify is going to be. If the real estate agent is truly an independent contractor, and I know you have good attorneys here at the Real Estate Association, given seminars probably on that topic over the years. And an independent contractor has to meet all these tests that our state Supreme Court has laid out in the decision. Whether it's a question where we've got whether a person is an employee in terms of OSHA covering them or payment of wages law covering, or IRS covering them as far as payroll deductions. So yeah, if you truly meet the test and those questions that are asked in determining whether a person is an employer or contractor, then no. If you're a business and all your agents are real estate agents who are independent contractors, and you don't have any clerical staff who would be considered an employee, and you don't have payroll staff, accounting staff, then no, you wouldn't have to comply with this law. But if you've got one employee, then you have to comply with this law. Absolutely not. They were not accepted under the old law, and beginning January 1, 2012, whatever, they're not even accepted on the I-9 form, as I recall. But regardless, whatever documents you have in hand as part of the I-9 process, beginning January 1st, 2012, you'll have to take the information off the I-9 and enter it into the EVerify database. And if EVerify says that the person is good to go, then you're covered under the South Carolina law. Oh yes, it applies to any trade association, the real estate association, nonprofits, anyone that employs one or more employees in this state. Okay, well, let's wrap up here real quickly. Remember, once you begin using EVerify, you must EVerify new employees and do that verification within 3 business days. In a seminar or webinar as this one, I probably say that 10 or 15 times. I do that because there's always someone who will miss that point. In fact, I did a seminar in the lower part of the state a few weeks ago, and there was a television reporter in the room, and went back that night and did a story on the evening news, and he said that beginning January 1st, 2012, employers in South Carolina will have to verify all their employees working for them, regardless of hire date, through EVerify. Leading to employers, and because under the EVerify rules set out by the Department of Homeland Security, you can't do that. You can't go back once you enroll and verify people already on the payroll. You can only verify new hires. And say it over and over in this seminar, enroll in EVerify, you only verify new hires coming on board from that enrollment date, or under the South Carolina law, our expectations are and you'll be asked to download two posters when you enroll in EVerify. One is the EVerify poster that lets everybody know that you're participating in EVerify. Some employers put it right on the front door of their business because it saves them a lot of wasted effort and time in dealing with someone who might have phony documents that would not clear EVerify, because they know that if you're an EVerify employer that they're wasting your time and then the second poster is required by the Department of Justice, letting employees know that they can't be discriminated. And this talks about how you handle those tentative non-confirmations, and keep in mind that you don't sway the employee either way as whether they'll contest it or not contest a tentative non-confirmation them, and you don't discriminate against them if they elect. Don't. Wrapping up, there's an email address where you can pose questions directly to EVerify. When you go on the EVerify website, there's a toll-free number, and to their credit, unlike a lot of government agencies, they're real people who answer the toll-free number at EVerify. Link there again is there for you to go and enroll in EVerify. There is our EVerify website. Well, not EVerify, but the state LLR immigration website and email address. One more minute. Any last minute questions? One or two more questions real quickly. Yeah, if you have one employee under the South Carolina law, you're covered by. Don't get confused by what North Carolina is doing, because they set a threshold of 25 employees or more. Georgia has set 10 or more. But our state legislature elected to make it one employee or more. Yes. Yeah, I think the Real Estate Association is going to post it on their website for us. Okay, I think our time is up, and those are all the questions. And again, I appreciate this opportunity provided me by the South Carolina Real Estate. We're traveling the state, speaking in person and via the web to anybody and everybody, because we don't want any employer to be surprised by this. January, and as you can see, it has severe consequences for failure. Thank you again for your time.